situation that Barbara has found herself in. Don gave me his original trust. That's why that will was so important. This property is not listed anywhere among his estate. Okay? And so all of this information Kevin has.
Just so you know, and even when I talked to Barbara's attorney this week, no one has found a signed will for Dawn. So one of the things I address in the tentative agreement that I sent to you for your review is having Barbara do a new affidavit transferring title from Dawn to her, because in the original affidavit she says that he has a will, that she gets whatever is under the will. Well, they have not found a signed will yet. They have an unsigned copy, but that's not enforceable under Nebraska law, so there is no will.
Nicole, I actually sat in 2017 in the Humphreys house. I was there practically every day. And one morning I would go around to the back door and I knocked on the door. They were sitting at the table with the will. And because of the way the will was folded, the very next time I saw it, I was able to recognize it. Barbara, he was in the hospital. She had it there by herself. So she has the original will.
Well, her attorney says, and I can only tell you what I at least know from the communications I had, and because one day I went over to our attorney's office because I wanted to review it. They have a copy or a document with no signature on it, which is not enforceable. So it's a will that someone drafted for Don, but it doesn't have his signature on it. And they don't even have so in Nebraska, when you do probate a will, you are supposed to probate the original with the original signature on it. There are exceptions that you can sometimes, for certain reasons, probate a copy if you can claim that the original was lost. But they don't even have a copy of his signed will. So, and like I said, I did double check that this week when I called to give Barbara's attorney an update, let him know that we'd put the documents together, we're reviewing them, and after we're done reviewing, we would send them to him. But I asked him again that if they had located a signed, either original or copy of Dunn's will, and he said no.
They haven't.
Well, for whatever reason, that Barbara's not telling her attorney the truth. I don't know.
Property.
Well, I'm back out here at storage, and being outside, being other people have storage units around you, you're gonna have a little background sound. And at the same time, I'm close to the street, so more than likely you're going to have vehicle sounds running by, motorcycle sounds running by, and all of that. But this is pretty close to the last day of January 2025. And I've just finished taking a few things out of the garage and putting a few things back in after finding what I wanted in some spots and didn't find what I wanted in other spots. But all that being said, I believe that all of you are entitled to an explanation for what you just heard. And what you just heard was a tape-recorded telephone conversation between myself and a Nebraska attorney, Nicole Sickman-Gillick, who works with the Abraham Caslow and Castman law firm, and that's located on 8712, I think, West Dodge Road, Suite 300, and that's 68114. On September 16th of 2018 was when all of this started. There had been three people: Elizabeth Humphrey, we'll call her Elizabeth; Joe Hendricks, we'll call him Joe; and Barbara J. Humphrey, Barbara. They conspired to try to attempt to make me pay them $16,000. Now, they were claiming that I still owed this money to them because of a loan that Barbara's husband, Donald Humphrey, we'll call him Don, had loaned me back in 2015. Now, Barbara had been present when the remainder of that loan was forgiven. But when it come time to file in false statements on the affidavit, everything went the other way, okay? So now Elizabeth and Joe and Barbara, they attempted to extort this $16,000 from me, and that failed. And this failure led them to threatening me, okay, and attempting to scare me through intimidation. And that's unlawful. That's criminal, I would say. And they started telling me that if I didn't pay this money, this $16,000, that they was going to force me to sell my house. Simple as that, or lien in my house. And that's our primary residence. And the real estate property that's in, it ended up in court. I put it that way. And this once the sale was supposed to be completed, this proceeds were supposed to be split between them and Lynn and me. The problem is that with the attorney that they had, this guy, he come up with all kind of ways to screw you around. And he knows all the judges in the Douglas County, Nebraska District Courthouse. And so it's very easy for him to once they get you isolated behind those closed doors, they can do whatever they want to you. And no one is going to know the difference, okay? Because they're the only one that's in there, other than the people that they're going up against. Now, I've heard that 92% of podcast listeners listen to podcasts for educational reasons. And I'm hoping that all of this is true because you're going to learn something. You're going to learn some things here on Hound Dog News that some of you won't believe. I just put it that way. You won't believe it. But before I begin to get into these lessons, I want to set a few things straight, okay? Every time that I'm out in public and I attempt to share Lynn and my experiences with people, the first thing they want to know is, do you have an attorney? Or did you hire an attorney? This lesson will answer these questions for you. This podcast episode will answer those questions for you. Questions have also surrounded whether or not our real estate property was co-owned in any way as tenants in common. Rest assured, people, that it is not. Okay, this property is owned by Lynn and me, and no one else is entitled to it. Okay, in order for real estate property to be co-owned as either joint tenancy or tenants in common, the property must legally be jointly owned according to law, not just by putting your name on an affidavit or a piece of paper and turning it into the court and saying, okay, I own part of the property. And that's what happened in this case. So in this situation, our real estate property is not jointly owned. Okay, it's not by joint tenancy or tenants in common. Okay, lawfully, we are the sole owners, or I am the sole owner of this property. Simple as that. And therefore, a tenant in common argument in this situation is not relevant because Barbara does not hold an interest in this property. Okay, it's as simple as that. So if people here in Omaha, Nebraska, take a look at this episode, I'm hoping that they will understand that and stop asking me, or stop asking us, okay, is it tenants in common, and all this off the wall stuff, because none of it is relevant in here. So anyway, having this said, by September 26th of 2018, Elizabeth, Joe, and Barbara, well, I should say Elizabeth and Joe had managed to convince Barbara that she'd been entitled to this $16,000 they was claiming I owed, and that she needed to hire a Nebraska attorney. Now, they chose Nebraska attorney John C. Chatelain, license number 15925, to represent Barbara, okay, in this fraudulent case. So on this September 26, 2018 date, John Chatelain prepared and presented, or I should say he filed false statements in Miss Humphrey affidavit. Okay, so he prepared it without probate against Lynn and my real estate property, and he submitted it to the court. To view this fraudulent affidavit, all you need to do is visit hounddognews.org, click on case evidence. That's what you want to do first, and then you want to scroll down to number 2, affidavit for transfer of real property without probate, and you can view it there. What John Chatelain did in preparing and presenting this affidavit to the Douglas County District Court violated Nebraska Revised Statute 3024-129 A8. Okay, so it violated Nebraska Revised Statute 3024-129 A as in Apple 8. Okay? In this rule, it writes that any person or persons claiming as successors under the affidavit swear to affirm or affirm that all statements in this affidavit or in their affidavit are true and material, and further acknowledge that any false statement may subject them, the person or persons, to penalties of perjury. Okay? And that's what happened in this case. So Barbara's affidavit to transfer of the real estate without probate had contained false statements under line 5. Now, number 2, number 5, and number 6 were all three false. Okay? But number 5 is the most relevant because under number 5, she claimed, I am entitled to the real property per the will of the deceased. Now, none, her deceased husband, is the person she's talking about. Now, keep this in mind too, okay? At trial, Barbara testified on May 23rd that her and Dunn were together when they when they signed their wills, okay? And that was in 1980, was what she testified to at trial. She testified that we signed it when our first child was born, okay? So there was absolutely no way possible. The will was never changed. So there was absolutely no way possible that lending my property could have been in that will because we didn't purchase the property until 2015. Okay, this was 40 years after her and Dunn had already signed the will. Okay, as I move forward or make advances to show proof of my causes, okay, you personally witness how Barbara's false claims on her affidavit was handled by this presiding judge, Dwayne C. Doherty. After Judge Chatelain prepared and presented the false statements on Barbara's fraudulent affidavit to the court, and this was on September 26, 2018, then on November 1st of 2018, Judge Chatelain had also gone further by preparing and presenting false statements in Ms. Humphrey's complaint for petition. Now that was on November 1st. The manner in which this complaint for petition had been drafted clearly disclosed its intent to force Lynn and me to sell our real estate property, and as well as to force us to share the proceeds from this sale with Ms. Humphrey and her attorneys. That's the bottom line. So she's going to get half, and her attorneys are going to get the other half. Okay, even though it's a fraudulent case. So just as Barbara's affidavit had contained false statements, the complaint for petition had also contained false information that would eventually disclose to the white. Let's say it would disclose of what's known as a white-collar government scam. Okay, you did hear me correctly. It's a white-collar government scam. The $16,000 amount that Barbara, Elizabeth, and Joe had originally claimed and continue to claim was still owed to them had been calculated with the assistance or with the use of what's called an amortization schedule. Now, all this is a payment schedule that was forged by Elizabeth Humphrey, and this forge took place on October 5th of 2018. And I'm absolutely certain about this because this document on this date was mentioned in an email exchange between Kevin O'Keefe, who was also with the Abraham Sigmund, the Abraham Caslow and Casman law firm. Now, he was the assistant to Nicole Sickman Gillen. And that's on Dodge Street, like I said, 8712. And Barbara's lead attorney, Matthew Sathoff, the Sathoff Law Group. So Kevin was making this email exchange with Matthew Sathoff. So Matt Sathoff had known all along, okay, that this amortization schedule, or that the $16,000 that was claimed, he had known all along that it was forged. He'd known this. He'd known that it was forged because him and Kevin was talking about this on August 21st, 2019, in an email exchange that took place at exactly 4:24 p.m. And this is how the email read. This is Kevin talking to Matt. Section 1 of this attachment was not in your discovery documents. Instead, the amortization schedule your client made was attached. My client is under the impression this is a scheme to pass off the amortization schedule dated 10/5/2018 as a document that he made. Now, believe this or not, people, but this is exactly what Matthew Sathoff did. Okay. Now the email continues that that I was concerned about them passing it off as something that I made in an effort to deceive the court. So you can view this email exchange. Let's say go to hounddognews.org, click on case evidence, and then on number 14, email between Kevin and Matt. Okay, so on August 22nd, 2019, I had also gone to the Omaha Police Department and filed this document as a forgery. And so, that police report is attached to the amortization schedule that I'm sending you to hounddognews.org to review. Okay? This entire case was a scam. It's as simple as that. This entire case was a scam. And you had attorneys, my attorney working with the opposing attorneys. She was sabotaging our case. Okay? And I've been right when I said that, when I told Kevin that they was going to try to use that amortization schedule and claim that it was something that I'd made. And that's exactly what they did throughout the case. Now, being that Barbara was the plaintiff, in the plaintiff's answers to the defendants interrogatories, now they claim, let me say this, they claimed that in Barbara Humphrey's deposition from May 29, 2020, repeatedly, she claimed that she didn't use the amortization schedule. Okay? When I'm knowing she's lying. So, in her answers to the defendants, which Lynn and I were, in that answer, she had been asked by John Chatlin to how was it they came up with the point that I had only paid $8,000 of the original loan, which left the $16,000. And to put it in John Chatlin's own words, okay, he said, describe the basis for the calculation that Edward Smith has paid $8,873.89 on the loan. And this person, whoever it was, answered. Like I say, it was Elizabeth, Joe, and Barbara. So whichever one of them answered, they said that it was because of the amortization schedule. Now that was on, I think it was line 9 of the plaintiff's answer to the defendant's interrogatories. So if you want to take a look at that, you can click on case evidence, go to hounddognews.org, click on case evidence, and then click on number 7. Okay, the plaintiff's answers to the defendant's interrogatories. Now, Douglas County, Nebraska District Court Judge Dwayne C. Doherty had also used this same information that was obtained from this forged amortization schedule to order a fraudulent writ of restitution and that's what he used to obtain lien in my real estate property through fraud. That evidence, that information, that $16,000 conclusion that Elizabeth forged the document to come up with was the information that was used to steal our property, still into my property. So upon John Chatelain's filing Barbara's complaint for petition, Lynn and I had gone to hire our own attorney, and that was Nicole Sigmund-Gillick, her assistant Kevin O'Keefe. Okay, and she was supposed to be representing us. Now, folks, this is a situation when you hire an attorney, you place your full trust in these attorneys. Okay, you don't expect them to stab you in the back, trusting that they will act on your best, in your best interest, I should say. And besides that, your beliefs are that your own attorneys are doing whatever is necessary to win your cases for you and not conspire with the opposing parties to sabotage your case. Bottom line. But the tape recording you just heard, okay, between Nicole and me had clearly been recorded. Well, I would say it was recorded on January 14th of 2020. Okay, and this recording clearly speaks for itself. And this recording undeniably shows evidence that proves that all attorneys don't always do what's necessary to help their clients to cross that very thin victory line. It's hard enough to fight these sort of crimes or criminal cases. And when you have your own attorney to stab you in the back like that, to sabotage your case, something is wrong with that. So this recording offers concrete proof, okay, showing that Lynn and my own attorneys were conspiring with the opposing party while sabotaging their own clients' chances to be victorious. What Nicole and Kevin did to Lynn and me is considered client abandonment. It's when your own lawyers stop representing you without providing adequate notice or explanation. So why did they cross over that line? Was it money? We had already given them money, you know. Approximately, they worked for us approximately 14 months, okay? And we had paid them about $17,000. Forgive me for that. I'm sorry. One example of them sabotaging us, once discovery begins, it usually takes law firms or a lawyer approximately 6 months to get to the deposition phase of a discovery. Okay? In Lynn and my case or situation, we had paid them over a period of 14 months for the results that never came. Nicole and Kevin never reached the deposition phase of our case. Their inactions left me to take Barbara's deposition on my own, myself. On May 20th, I started it, and we didn't conclude it, and then I jumped to May 29th of 2020. Okay, so John Chatelain had prepared and presented false statements on an affidavit to the district court, whereas Barbara had claimed to be entitled to an interest in Lynn and my real estate property per the will of the deceased person. Barbara had known all along, or reasonably should have known, okay, that Lynn and my property had not been in that will because she didn't have a will. That was number one. There never was a will. It was a lie the entire time. Meaning that without a will, though, the bottom line, without a will, there's an old saying, no will, no case. That's where Barbara found herself. Without a will, she didn't have a case. Okay? So this is why I felt that making this recording of Nicole saying that had been so important. To catch Nicole attempting to help Barbara's attorneys to establish a credible case that they wouldn't have had without amending that affidavit. On that recording, you could hear Nicole attempting to talk me into letting Matthew Sathoff. Okay, that ended up being Barb's lead attorney. She wanted to talk me into allowing him to amend Barbara's affidavit. Now, Matt Sathoff, he owns the Sathoff Law Group, okay, PCLLO. I think it's located at 440, I think I've said, 440 Regency Parkway in Omaha, Nebraska, Suite 132, zip code 68114, okay? Now, but I wised up. I did not let her amend that. I didn't tell her to allow Matt Sathoff them to amend that affidavit. So that had been the claim, okay, that the property had been in Don's will. And even though, and we knew that it wasn't in there because the will didn't exist. And another thing is that the trial transcripts also provide evidence needed for proving that this will never existed. Barbara's entire case was built atop these fraudulent claims and false statements, and Judge Doherty relied on these same false claims and statements, okay, to obtain our property through fraud. He ordered a fraudulent writ of restitution when he knew up front, before he ordered that writ of restitution, that there was no will. He knew this, okay? Like in March of 2022, okay, this case had gone before the Nebraska Supreme Court, okay? And the High Court offered its opinions as well as given directions, and this happened on May 27, 2022. The High Court reversed in part because Judge Doherty had already ruled in favor of Barb's motion for summary judgment, okay? And the High Court reversed that in part before sending this case back to the lower court for trial because we didn't have a trial. Judge Doherty was screwing us on every angle, from every angle, and we didn't have a trial. So the High Court sent it back for trial with directions. It wanted Judge Doherty to allow us a trial, and he wanted Judge Doherty to verify the will. Well, guess what, folks? What a mockery that turned out being, okay? A sheer mockery of justice, okay? An unparalleled insult to the bench. Thank you, Judge Doherty, okay? But now during this unfair trial that failed to follow the proper principles of due process as defined under the 14th Amendment and violated the equal protection clauses protected under this same 14th Amendment. Okay, the trial's conclusion resulted in an injustice as well as excessive punishment against Lynn and me, which eventually led to Judge Doherty's ordering a fraudulent writ of restitution to obtain Lynn and my property through fraud. During the trials dates, which was April 10th, April 10th, 11th, and May 23rd, okay? Nebraska attorney, now this is how unfair this trial was. Anytime an attorney, okay, decides to tell the judge, okay, that you wish this was fair, something's wrong with that, okay? Lynn and I already knew this, but then you get an attorney. So, and this took place, I would say, on April 10th of 2023. Nebraska attorney Donetta Sanders, her license number is 22964. She questioned Barbara under oath as follows. And now this is on page 241, lines 16 and 17, Miss Sanders, okay? She's asking Barbara, have you presented the will as part of the case? Then on page, the same page, 241, line 18, Barbara said no. Now you can view this document on hounddognews.org. Click on number 5, trial excerpts, okay, from April 10th and May 23rd, 2023. Unlike the false statements of having a will, Barbara claimed in her affidavit that she had claimed in her affidavit during these 3 days of trial, not once had Barbara perjured herself by continuing to falsely claim that this will actually existed that entitled her to an interest in Lynn and my real estate property. In fact, Barbara's testimony had been the exact opposite, people. The exact opposite. During this unjust trial, Lynn and my civil rights were violated. I'd been forced to litigate pro se myself, therefore allowed to question Barbara under sworn oath on my own because we no longer had attorneys. This was on May 23rd. And on page 656, okay, now you keep this in mind. For 7 years, well, at that point, it was 5 years. But for 5 years, this woman has lied and said that there was a will that Dunn had left behind that had my property in there, okay? But on page 656 of the trial transcripts that were taken on May 23rd, 2023, Barbara testified on line 12 of this page 656, okay? Your property, and she just shot this out, your property is not in the will. Okay, now following this admittance, I followed up on line 13 with, I know it's not in the will. And Barbara concluded this line by concluded on line 14 with, that's correct. We didn't want it in the will. So from this point, Barbara's testimony is, okay, I should say, let's just go, I'm going to have you to go to page 659. I put it that way. And look at lines 9 through 12, where Barbara had testified as follows, okay? I'd come out and said, thank you. And then I said, now you're sitting here telling me, or telling the court, that's a truck going by, excuse me. Like I said, I'm at the storage. I told her, I said, you're sitting here telling me or telling the court, may I have that? I was asking her for the document that I'd asked her to verify. And then I continued. You're sitting here telling the court that Donald Humphrey had a will. Is that correct? And then line 13, she said, Barbara said, he had a will. She was trying to beat around the bush. He had a will. And then I say on the line 14, I'd asked, a signed will. Is that correct? And on the line 15, she said, Barbara admitted that house is not in the will. Now, why didn't she just come out and say, yes, the will was signed? You see what I'm saying? Instead, she just come out and again said that house is not in the will. Folks, Judge Doherty intentionally disregarded every single word of Barbara's testimony under oath and found the court itself having to admit to that it did not have a will. This is how Douglas County, Nebraska District Court Judge Dwayne C. Doherty addressed this issue on page 765 of this transcript. And this was on May 23rd, 2023. Okay, look at, if you go to Hound Dog News and look at this, you're gonna be looking on the lines 2 through 5. Here's what the court, that was the same lady that just drove through, excuse me. The court does not have a will though, sir. So the contents of the will are not going to be considered by the court because I don't have one. To view this trial transcript, like I say, visit hounddognews.org, click on trial excerpts from April 10th and May 23rd of 2023 and go to page 765, and you can find it there. So during this case at trial, Judge Doherty disclosed his involvement in this white-collar government scam with Matthew Sathoff, John Chatlin, and James E. Reisinger. Miss Reisinger's license number is 19990, and he's with the Reisinger Booth and Associates, PCLLO, at 7602 Pacific Street, Suite 222. That's in Omaha, Nebraska, and I think the zip code there is also 68114. Okay, they was involved in these illegal activities and wrongdoings that eventually led to Judge Doherty illegally ordering a fraudulent writ of restitution to obtain land in my property through fraud. It's as simple as that. A criminal conspiracy, whereas Nebraska Attorney Donetta Sanders had basically pleaded with Judge Doherty beforehand, okay, before April 10th. Okay, well, I should say on April 10th. I apologize for saying before. It was on April 10th, where of 2023, she pleaded with him to allow a fair trial by stating to the court as follows. On page 116, line 9 through 10, Ms. Sanders argued as follows. In addition, all things being considered, the timing of how one is really being fair noticed under circumstances. Is not being fair noticed under circumstances. Then on page 116, on the lines 21 through 23, Ms. Sanders argues, and I would just ask the court to consider that argument and allow a fair chance to us to be able to present these issues. Judge Doherty eventually got rid. Him and Matt Sathoff pulled some little stunts, and then Miss Sanders and the attorney we had working with her, Judith Wells, they eventually withdrew on April 21st. But the point was, and that was because they wanted some more money, and we wasn't ready to cough that. Lynn and I wasn't ready to cough that up. Okay? So under questioning by Matthew Sathoff, I myself voiced my concerns about the fairness of the trial. Testifying on page 302, lines 15 through 18 as follows. Okay? Let's see how it was. Page 302, lines 15 through and 16, Matt Sathoff said, "Sir, you said you wrote that August check in July 3rd, correct?" And then lines 17 and 18, I questioned, "Am I getting impeached for that too?" Because he was constantly impeaching me on Lynn and my relationship. That had no relevance in this case. Okay? We can be with who the heck we want to be with. That had no relevance in this case. So clearly, this was not a fair trial. That's what I was telling him, or telling the judge. And like I say, to view this, click on trial transcripts, and then on April 10th, 2023, okay, in section 1. That's in section 1 on that. And the laws, Judge Doherty, of this here country called America do not, this is what I'm telling the judge, do not support judges who abuse their powers. And I take that back. I wasn't telling him that at trial. That's what I'm telling him on this here podcast. Okay? The laws, Judge Doherty, of this here country called America do not support judges who abuse their powers. And in Lynn and my case, it cannot be denied or disputed that you, sir, Judge Doherty, undisputedly abused your powers and discretions. And when defendants have corrupt judges like yourself, sir, presiding over their cases, not me, not Lynn, not anyone else can predict how these sorts of cases will turn out. You're a racist in my beliefs, sir, And because protected, you're protected by Nebraska's structural racism laws. I put it that way. And that's why you can get away with what you're doing. A person's skin color determines the outcomes of your orders and your rules in your courtroom. Okay? Just like Donetta Sanders said that she was wishing that we could get a fair trial, Lynn and I was wishing the same thing. But what all of us can agree on, Judge Doherty, is that what's right should always conquer what's wrong. Unfortunately, when we stir up a mixture of unethical attorneys and toss in a corrupt judge and expect to come out with a stew, I don't believe that's going to happen. Okay? Just the smell on this concoction alone will substitute for the taste. And believe me when I say that is a nasty stew. Filthy, corrupt, and this sort of criminality will remain with the person for the duration of their entire life, Judge Doherty. You, Judge Doherty, are in a position of authority, sir, and you've used your power in an unjust and harmful manner to unjustly order a fraudulent writ of restitution to illegally obtain land in my real estate property through fraud. And that's exactly what happened. On May 27, 2022, the Nebraska Supreme Court gave you directions, sir, to allow Lynn and me a fair trial and to have Barbara to establish her ownership to the property's title. Otherwise, she'd had no right to a petition of Lynn and my property. Sir, Judge Doherty, you intentionally disregarded the High Court's opinions and the directions handed down to you by this High Court, and to have Barbara to establish her ownership to the property's title. You did not do this. 5 years passed. Lynn and I have suffered from Barbara's false statements, and you've sat in the trial and disregarded her direct testimonies of not having the will. You yourself said that the court didn't have a will. So now, on this date, 7 years have passed, and no one has ever seen this will, not even the court. Okay? You won't even allow Lynn and me a fair trial. You wouldn't allow it. Okay? You wouldn't allow us to do evidence, to offer evidence. Nothing. Barbara sat before you, continuously admitting that she didn't have a will. Okay? This case, I don't know what to say, Judge Doherty. Okay? I'm pretty much tongue-tied. Okay? In Lynn and my Douglas County, Nebraska District Court case number CI 18-9530, you, sir, committed a serious breach of judicial ethics. Donetta Sanders and Judith Wells saw this coming. I'd seen it coming in your activities, and so had Lynn. Discriminatory judges should not commit these crimes from behind the bench, sir, especially when they're in their own courtroom. That just blows my mind. You're in your own courtroom doing this. And as far as Matthew Satroff goes, any attorney who abuses the process itself, okay, seems like me that should be criminal. I got to research that, okay, because the abuse of process is when an attorney intentionally misuses the legal procedures for an improper purpose. And that's what he's done. Okay? He's harassed us. He's continuously intimidated us, an enemy. And it's one of those things too. He exerted undue pressure on an opposing party. And this is against the law. And he knew it was against the law. Did he care? Nope. I don't think so. So in this case, Humphrey versus Smith and Proslow, Matthew Sathoff used the legal system in a way that it was not meant to be used. Okay, he used the legal system in a manner that he known would achieve his motive, and that's exactly what you did for him. Okay, he'd known that his actions were criminal with intent, and he'd also known that he should not use the legal process for its. He did not use the legal process for its intended purpose. Okay, but only to achieve his personal goals outside of the legal purpose itself. Okay, it had nothing to do. What he did had nothing to do with the case. Everything he did had everything to do with trying to harm Lynn and me. Okay, it's as simple as that. So, and this describes the actions taken by himself, Matt Sathoff, by James Reisinger, by John Chatelain, by Nicole Sigmund Gillett for crossing that line with him, and by Kevin O'Keefe. So, Mr. Sathoff, you, Judge Doherty, John Chatelain, James Reisinger, Nicole Sigmund, every attorney that was been involved in this case, okay, you was able to, when Darnetta Sanders and Judith Wells stepped down because we wouldn't give them any more money, that allows you and Matt Sathoff to isolate Lynn and me from the eyes and ears of the entire outside world where you committed your frauds, okay, out of sight, from behind the doors of the courtrooms, okay, and you have hurt Lynn and me financially, mentally, and every other way possible that a case like this could possibly hurt a person. You've accomplished that, sir. As of 2025, this year, okay, for nearly 7 years now, Lynn and I suffered far beyond just pain and mental anguish, okay? But thanks to you, Judge Doherty, and your friends, James Reisinger, Lynn and I have also lost our real estate property as you achieved your white collar government scam. You achieved it, okay? So, folks, some of you may question, how was it possible for Barbara to falsely claim on her affidavit that a will had existed entitling her to an interest in our property, okay? And then change her claim at trial to testify on the sworn oath that our property was not in this will. And you might also ask yourselves, how had Judge Doherty been able to order a fraudulent writ of restitution obtained through fraud to force the sale of Lynn and my property without proper cause? Because legitimate courts cannot sell a person's property without probable cause. This court did it, and it didn't have probable cause. Okay? In fact, the Fourth Amendment itself of the U.S. Constitution protects against reasonable seizures of property, which typically requires a warrant based on probable cause. No other reason, not an affidavit, probable cause. Okay? It requires that before a court can order a property sale, except in specific situations like foreclosure. And clearly, this was not a foreclosure. In fact, the Fourth and 14th Amendments due process clauses guarantees that people cannot be deprived of their property without due process of law. You fail to offer this. You fail to allow this, Judge Doherty. This means that people should be given notice and an opportunity to be heard before their property is taken. You, sir, did not allow Lynn and me the opportunity to offer our evidence at trial. You, sir, did not allow Lynn and me to present, to even basically talk at trial. We was only allowed to say what you wanted us to say, what Matthew Sathoff wanted us to say, and that was it. So the answer to your questions, people, America, of how could Judge Doherty have taken land in my property is simple. Judge Doherty conspired with the attorneys and a list of other attorneys. I put it that way, a whole list of them. He conspired and he violated Title 18 U.S. Code Section 242, deprivation of rights under color of law. A state employee or federal employee working under state of law, like police officers and judges, pardon me, okay, can be arrested for violating Code 242. But the bottom line is Nebraska still practices structural racism laws. Okay? These are infrastructures of laws and ordinances that give certain ethnic groups rights and privileges while denying these same rights and privileges to other ethnic groups. In Nebraska, historical, cultural, and social, psychological, racialized society is what exists here. A system of organizational and institutional policies created over time and supports a continued unfair advantage for some people while unfair and harmful towards other people. If you're white, you can have these. If you're black, you're on the losing end every single time. And Judge Norton knew this. Matthew Satoff knew this. Okay? And others. That they know that they're protected by these laws. And therefore they have no fear. They can violate your civil rights. They can cut your head off. They don't give a damn. They know they're protected by these laws. Okay? So in my case, a review of the trial transcripts themselves, okay, will disclose that Judge Doherty conspired with others to deprive Lynn and me of every effort to be heard by his unjust trial, or I should say, at his unjust trial, or in his unjust trial. And Lynn and my evidence had been inadmissible, or in the judge's own eyes, not worthy of being admitted. Okay, even Barbara's testimonials of were, I would just say, even her directly telling this judge, testifying under oath, that our property was not in the will. Didn't matter to him. He disregarded that, just like he disregarded the directions of the Nebraska Supreme Court. So it's as simple as that, folks. It's as simple as that. In order to accomplish Matthew Satoff, John Chatlin, James Reisinger, and his own personal goals, Judge Doherty had no other choice but to violate Lynn and my civil rights. Okay. Additionally, this judge had also disregarded, like I say, the directions of the High Supreme Court. It's as simple as that. Okay. The High Supreme Court made it perfectly clear, and I quote, and this is what one of the things Judge Doherty did not do, did not follow. The court made it clear that Barbara Humphrey needed to provide proof to the court that she was entitled to that property. Okay? And the only way she could do that was to show a copy of the will that she did not have, a will that did not exist. Okay? So if you go to houndoutnews.org and you look at, read just the I think it's 17 pages in the Supreme Court document from May 27, 2022. Okay, and you will see under 642 the opinions of the Supreme Court, and I quote, they said it just like this: the real controversy in this case, okay, I won't say in this case, it said the real controversy in this case is the issue of title, and the petition is an incidental to the issue of title. If Barbara does not succeed in establishing her title, she has no right to a petition. End of quote. So, folks, during the 3 days of trial, Judge Doherty neglected and therefore required He neglected to require Barbara to establish her ownership to the title. Every time the word will came up, because there wasn't a will, every time the word will came up, Judge Doherty allowed Matthew Satoff to scream objection, relevance. The will was the only relevant thing in this case. That's why we was there. That's why this case exists, because she claimed to have a will. Okay? She claimed to have a will. Barbara did. There never was a will. Okay? So what Judge Doherty did at this trial was a sheer mockery of systemic justice. Sheer mockery. We'd like you to review all of the trial transcripts or records at hound.news.org and experience this lack of justice or injustice for yourselves. As you read, you would not find where the will was addressed. Simple as that. Judge Doherty deprived Lynn and my every effort, and I'll say that again, our every effort to achieve our goals, to save our real estate property. And this included violations of the Fourth and 14th Amendments, or the Fifth, and the due process and the equal protection clauses guaranteed under the 14th Amendment. Now, I don't know if any of you are familiar with what's called the Black Code laws, okay? But these were laws that started in the old days of in the old days of slavery. And they were known as the Slave Code laws. After the Civil War, these laws were supposed to have been abandoned, but they established white superiority over blacks, and they didn't want to abandon them. So instead of getting rid of these laws, they renamed them Black Code laws. Okay, and then these laws went on to become the Jim Crow laws. Okay, so that's where that comes from. So under these laws, though, black people, or black Americans, I should say, are not allowed to be involved in any legal litigation against white people in court, okay, or in a court of law. And any evidence or testimonials offered or given by black Americans in a court against a white person, or testifying, uh, anyone's testimonials that might favor or benefit a black person, okay, in a court during this period of trial is considered inadmissible. And that's what happened with Barbara. Okay, she sat there in front of the judge and she admitted that our property wasn't in the will, and Judge Doherty ignored it. It wasn't admissible because it would have benefited Lynn and me. Okay? He did not allow us to get any evidence in. Okay? So the bottom line is Barbara Humphrey never established her ownership to the title. That was her. The plaintiff always has the proof of burden on them. And her proof of burden was to establish ownership to the title. She never did that. Not once. Okay? She never did that. And if she had, the court would have been able to verify it. But Judge Doherty never verified. What Judge Doherty said, the court doesn't have a copy. I don't have a copy. Okay? And so the bottom line is these attorneys, along with the judge, violated our civil rights. They obtained our property through fraud. And then James Reisinger put our property up for sale. It's as simple as that. So yeah, right now we're hurting. I'm sitting out here making this video. It's cold out. Don't get me wrong. But I feel it's important to get this done. I feel it's important. Okay? I don't know. I'm going to add this, and then I'm going to put this one down. When the court ordered the sale, okay, they did it through a bench trial order. And the bench trial order, the only reason that the court gave, now keep this in mind, Judge Doherty didn't draft this bench trial order. Matthew Satoff drafted it. And I know this because of the way he writes compared to the way Judge Doherty writes. So, but Matt Sathoff is very good in playing with words. And the only reason given in this bench trial order for forcing us to sell that property was the affidavit. Matt Sathoff said, or the court, I'll put it that way. I won't say the court or Matt Sathoff or George Jordan. I should say the court. The court said that the Nebraska revised statute, I think it was 30, Nebraska 30-24-129. The court said that in its bench trial order that statute was revised in 2022, and that when it was revised, if you file an affidavit per the will has to be included. So the court argued that when Barbara filed her affidavit, it had been back in 2018, 4 years before, and therefore it did not need a will with it. Well, I look at it this way, and the whole world will look at it this way, especially the country, America, I'll put it that way. When you file an affidavit, whether it was needed the will or did not need the will, it still has to be truthful. So the affidavit that they filed was void because it violated 30-24-129, A as an apple, 8. She perjured herself on that affidavit. So the affidavit was void, or should have been void. And it wasn't. And that's how we lost our house. Okay? We could use your help, America. We could use your help. This fight isn't over. Yes, financially we're ruined. But with your help, we can bring in someone from outside of this state that doesn't have to apply for their license here. And that's why we can't find a good attorney. Okay? That's why we can't find a good attorney, because every attorney here has to be licensed by the state. And since the state is propping up this structural racism law that's allowing what's happened to us to happen, if an attorney here go up against that, it's a probability that he might not get his license next year. She might not get her license when the term ends. So that's the bottom line. Okay? So I appreciate you guys being here with us on Hound Dog News. My name is Ed Smith, and we'll see what happens with episode 3.